Orders, item 5.
Please, Your Lordship. My lord, in this matter, we have sent the officer in charge the request to serve the notice on 24th November 2024. The same is not returned till date, and I could not get a hold of the officer in charge for contact as of now.
No, which item are you talking about?
Item 5.
This is RFA.
Oh, I'm sorry. I thought it's a criminal appeal. My sincere apologies.
Okay.
May I please, Your Lordship?
Yes.
In item number 5, Lordship, the service already completed, Lordship.
Hmm.
I think all the respondent entered their appearance, Lordship, and appeal has already admitted, Lordship. Kindly LCR may be called for.
What is? Please write, parties are represented by the respective councils. So although the appeal was admitted, notice has not been issued. So let notice be issued. So since parties are represented, no formal notice is required. Office to requisition the LCR and list the same once it is received
Lordship, a date may be fixed is
in the orders column. We don't know. I'm saying that whenever it's received, it will be listed. Or if you want a date, you're an outstation.
yes,
Right.
yes, Lordship. That's why.
We don't know when the records will come from where.
As a Lordship.
Okay. You tell me when is it convenient for you?
Lordship, in the month of June, second week,
June.
or last week of June.
What do you say? Other side.
No objection, my lord.
Then you write call for the LCR. Okay. Then call for the LCR. Then list the matter. You said last week or first week?
Last week, Lordship.
23rd of June.
23. Obliged, Lordship. Obliged.
Item 6.
This IA is for delay. So I believe they're yet to submit their
Yes,
objections.
my lord. If we may be granted 2 weeks' time to file a written objection against the IA. Wherefore, the respondent number 1.
How many respondents are there?
1.
3, my lord.
3, sorry, but
What about the others?
it's state, my lord. Pro forma respondents.
How much time you want?
2 weeks' time, my lord.
Okay. Parties are represented by the respective councils as paid for by Mr. Loma Maralte, Learned Counsel for respondent number 1.
Yes, my lord.
2 weeks time is granted. Further 2 weeks time is granted for filing objection.
Obliged, my lord.
Yes.
Item 7.
May it please your lordship. My lord, the affidavit will be able to file within a week, my lord. We have been able to serve a copy to almost all the private respondents except one person, which we cannot find. The rest of it, the copy has been served and we'll be filing the affidavit, my lord.
My lord,
Okay, yes.
we will be appearing for all the private respondents. We will be filing our vakalatma within this week. And in the meantime, I pray for 2 weeks' time to file affidavit in opposition.
This is an LA appeal, isn't it?
Yes, your lordship.
What is the procedure? One files affidavit in opposition in LA appeal
There's a delay, my lord. I believe they want to
for
file
the
an
delay.
objection, my lord.
Of
on the
condemnation.
delay.
Sir.
Okay. Mr. Samuel Banerjee Sangtel, an additional advocate general, appearing for the applicants, submits that they have been able to serve notice to all the private respondents except one of them. Stop. He submits that he will be able to file the affidavit on dusty service within a period of 1 week. Stop. Next para. At this stage, Mr.
Lalchan Puya.
Lalchan Puya, learned counsel, appears and submits that he will be appearing for all the private respondents. What about your vakalatnama?
So we will be filing this week.
And he prays that he may be given a week's time to file his power. Stop. Considering the submission made by the learned counsel, notice is deemed to be complete upon all the private respondents. The requirement of filing affidavit of dusty service is waived. You still want to file or
No, my
not?
lord. If they are
Is
appearing,
waived. Is waived. As prayed for by the learned counsel appearing for the private respondents. How much time?
So 3 weeks time.
3.
3.
3 weeks time is granted to file the objection to the IA. List again after 3 weeks.
oblige, my lord.
Item 8.
My lord, I have taken dusty steps on 4/3/2025. However, dusty service is not yet completed.
So,
My lord, my prayer are similar as previous one.
similar.
Similar prayers.
Okay, please write name of Miss Caroline Kelungoipui instead of Mr. Samuel. Everything is same. You need not file your dusty.
Yes, my lord.
He's appearing for everyone, so that is waived. And we've given 3 weeks time for filing objection. Yes.
Item 9.
Yes. 9.
My lord, similar prayer as the previous one.
Miss Caroline, this item 7, no, item 8.
Yes, my lord.
Where are you able to serve dusty notice to everyone?
Not yet, my lord. In item 8, not yet.
Item 8.
Yes, my lord.
You have not been able to.
We are attempting, my lord. We have taken steps on 4/3/2025. However, we are unable to serve the notice.
Okay. Okay, no problem. Then item 9.
Item 9 also, my lord, similar prayer.
I think we should change the item 8 order. It should not be repeated as 7. Item 8, you write separate order. Okay. Item 8. Heard Miss Caroline, you write like this. Miss Caroline K. Lungoipui, learned government advocate, appears for the applicants and submits that she needs further time to serve notice to the private respondents by way of dusty. Stop. At this stage, Mr.
Lalchan Puya, sir.
Lalchan Puya, learned counsel, appears and submits that he has instructions to appear on behalf of all the private respondents. Stop. In view of such submission, notice is deemed to be complete on all the private respondents. Stop. The requirement of filing dusty and the requirement of filing an affidavit indicating dusty service is therefore waived. Stop. As paid for by the learned counsel for the private respondents. 3 weeks time is granted for filing power as well as objection to the IA. Okay, that will be item 8, separate order. Then item 9,
My lord, item 9 also, steps have been taken. However,
you'll be appearing again.
Yes, my lord.
Okay. Please write down, office note indicates that dusty steps has been taken by the learned counsel for the applicant, but no steps as regards service of notice by registered post with AD due has been taken. Stop at this stage. Mr. Lal Tanpuya, learned counsel, submits that he has instructions to appear on behalf of all the private respondents. To stop in view of such submission, notice is deemed to be complete upon all the private respondents. The learned counsel to fire his power within 1 week, and 3 weeks' time is granted for filing objection to the IA.
Obliged.
Admission item 1.
My lord, I've been served a copy of the verification report. However, the report is in vernacular. I'll need to make a translation and file it accordingly, my lord.
What is the sum and substance?
That they have received compensation more than the area, my lord, in certain house passes. And some of his house passes are outside of the right of way, my lord. So it'll be better if it's translated and filed
By
by way of
act.
affidavit. my lord.
Yes. And apart from that, have you received any other instructions?
No, my lord. Nothing.
Let him file then. You get a chance to see the
Yes, my lord.
report
I've
also.
been served with a copy, my lord. And
Let him file it and bring it on record.
yes, my lord.
Mr. Samuel Banerjee Tatsangte, learned additional advocate general appearing for the state respondent, submits that he has received the verification report from the Deputy Commissioner Aizawl, which however is in vernacular. Stop. He submits that he may be allowed to file the same by way of an affidavit. Stop. In view of above, the verification report, let the verification report be filed by way of an affidavit with its translation within a period of 1 week.
Yes, ma'am. Obliged, ma'am.
Obliged, my lord.
Item 2.
My lord, on request of counsel for the petitioner, the matter may be taken up after 2 weeks. He has some personal problem, my lord.
3 weeks. Yes.
Wala na ka.
What is your instruction, Miss Caroline?
My lord, I have not yet received any instructions.
Are you aware about the nature of this case?
My lord, actually,
Huh?
this case is not handled by me. This case is handled by Miss Lemhindui. She's on let's see here.
Yes, what is the instruction?
Yes, Your Lordship. Your Lordship, the present matter was tagged with WA 12/2022, Wide Order 21 of February 2023, and then subsequently the WA was disposed along with the other cases by Common Judgment Order of 29/11/2024. And against the Common Judgment Order 29/11/2024, the state respondent had filed a SLP before the Supreme Court, Your Lordship, and in which the Honorable Supreme Court had wide 17th April granted a stay on the operation of the judgment order dated 29/11/2024, Your Lordship. If I may present the copy of the order of the Supreme Court, Your Lordship.
delay condone, issue notice, then stay. That is the order, is it?
Yes, Your Lordship.
So what to do with this case?
If it may be kept in abeyance, Your Lordship, until
No, that we can do, but another thing is that there was no counter affidavit.
yes, Your Lordship.
It was tagged along with the writ appeals.
Yes, Your Lordship.
Initially, it was a bunch of case,
Yes, Your Lordship.
all one big bunch
15,
of case.
yes, Your Lordship.
So in which the learned single judge has
Yes, Your Lordship.
interfered with the whatever that thing is there, riverine reserve or something,
Yes, Your Lordship.
and directed the state respondents to
Yes, Your Lordship.
pay the compensation. This case was left out. Then state filed an appeal.
Yes, Your Lordship.
So since it was left out, somehow it was mentioned and connected to the writ appeal.
Yes, Your Lordship.
And even when it was connected to the writ appeal, it was still again left out.
Yes, Your Lordship.
Orders were passed for the rest of the writ appeals except for this writ petition.
Yes, Your Lordship.
So under the circumstance, are you going to say that it will go by whatever is decided by the apex court, or you want to file a separate affidavit in opposition?
Your Lordship.
Case might be slightly different.
Yes, Your Lordship.
if I'm
On
not
that regard,
mistaken.
I can ask for additional information from the concerned respondents if they have any additional information to add up to this case, Your Lordship.
So it's entirely up to you. We'll give you that liberty to file a counter affidavit.
Yes, Your Lordship. If 3 weeks' time may be granted, Your Lordship, to
Yes. Now, in view of this stay order, then what to do? We list again after 3 weeks or what?
4 weeks, Your Lordship, because
Why not 6 weeks? Or why not 8 weeks?
the Lordship, because I'm not aware when will the matter will be
Exactly.
listed
That's
again.
why we'll take note of this fact and we'll say that it will be pending. This
Your
will be
Lordship.
kept in abeyance pending disposal of this
Yes, Your Lordship.
SLP. Meantime, you consider and file an affidavit
Your
if you
Lordship.
want to. Mr. Vanalngaka, learned counsel for the petitioners, is said to have some personal difficulty to appear before the court today, and a prayer for adjournment has been made on his behalf. To stop beat stated herein that this matter was tagged along with writ appeal number 12 of 2022. Right order dated 21/2/2023. Stop. The writ appeal was dismissed as withdrawn with liberty to file afresh, but no separate order was passed in respect of the instant writ petition. Stop. The writ appeal thereafter was restored to file in white order dated 18/9/2024 by the Supreme Court with a direction that the same should be considered by the division bench of this court. Stop. The constituted division bench disposed of the writ appeal along with similar other matters. White common judgment in order dated 29/11/2024. But in respect of the present writ petition, no separate order was passed. Stop. It is also seen that the respondents have not filed their affidavit in opposition against the writ petition. Stop next para. Ms. Lalnan Louis, learned government advocate, appearing for the state respondents, submits that against the judgment and order dated 29/11/2024, the state government has filed SLP C number 10724 of 2025 before the Supreme Court of India. And the Honorable Court, by order dated 17/4/2025, condoned the delay in filing the SLP, issued notice to the respondents, and also stayed the operation of the impugned judgment and order dated 29/11/2024. Passed in the writ appeals. Stop. She therefore submits that pending disposal of the SLP, the presented petition may be kept in abeyance. Next para, having regard to the order passed by the Supreme Court of India on 17/4/2025, staying the impugned order dated 29/11/2024, passed in the writ appeals, the present writ petition is deferred till final disposal of the said SLP. Stop. The state respondents, however, shall be at liberty to file their affidavit in opposition against the writ petition in the meantime, if so advised. Stop. Parties are at liberty to mention as and when the SLP is disposed of by the Supreme Court of India.
Much obliged, Your Lordship.
Item 3.
May I please, Your Lordship?
Yes.
I'm happy to inform this Honorable Court that the directions of this Honorable Court has been fully complied and the present contempt petition can be closed.
Okay, that's great. Who's for the other side? No one.
Miss Mary used to appear.
She's for which respondent?
She is for the respondent number 7. 7 would be the relevant respondent.
Only 7.
She's appearing for 2, 4, 5, and 7, but they're all the previous incumbent of the position holding district
Anyway,
collector.
we'll record that.
Right.
Okay. Mr. Lal Fakoma, learned counsel for the petitioners, submits that the direction of this court passed in which case?
LA Appeal number 1 of 22.
LA Appeal number 1 of 2022.
By judgment and order dated 12/7/2022.
By judgment and order dated 12/7/2022.
Deeply obliged.
Item 4. May it please Your Lordship. My Lord, the instant appeal has been filed challenging the order dated 11/2/2025 that was passed by the learned senior civil judge 6. However, my Lord, in the first page, while the certified copy has been issued by the Court of Civil Justice Senior Division 3. Because, my lord, the instant case, after passing of the impugned order, has been transferred from the Court of the Civil Judge Senior Division 6 to Division 3, my lords. So that is why the certified copy has been issued by the Civil Judge Senior Division 3. My lord, my case is that, yes, my lord. Yes.
Okay. So,
My lords, my case is that the instant respondent number 1, the deceased, she is my grandmother, and the respondent number 2 is my father. And the instant respondent number 1 had filed the declaratory suit number 12 of 2023.
grandmother means late.
Yes, my lord.
Number 2 is father.
Yes, my
He's also
father.
late.
No, my lord.
Okay.
And in the
Respondent means in the present
yes, my lord.
appeal.
My lords.
Then who has filed this declaratory suit?
Declaratory suit was filed by my grandmother, the instant respondent number 1. And during pendency of this declaratory suit, my grandmother, the instant respondent number 1, had died.
Okay. So,
And the instant respondent number 2 had filed a CMA application seeking for substitution of the deceased respondent. That was allowed by the trial court by this impugned order. And my lord, why we have impugned this order is that prior to the demise of my grandmother, an application was filed by her for impletement of the instant respondent number 2 as a party respondent in declaratory suit number 12 of 2023. However, since this declaratory suit was at the stage of final hearing, and that application was rejected. And also, my lord, the instant respondent number 2 had also filed yet another case, which is still pending. And in that case, the properties in dispute in this declaratory suit and that title suit are the subject matter are the same. While the respondent number 2 had filed a title suit against the instant appellant as well as the instant deceased respondent number 1. Yet in the instant declaratory suit, that person who had filed a case against my grandmother has been allowed to substitute my deceased grandmother. So that is why we have come before this honorable court.
quite complicated, huh?
My lord.
At one, your grandmother, Biak Moi,
Yes.
she filed declaratory suit for what purpose?
For declaration that some plots of properties, landed properties, which were registered in the name of the appellants herein, to be declared as her property, and for cancellation of those landed properties which were issued in the name of the appellants herein.
So who are the appellants then?
Appellants,
Are
my
the
lord-
grandchildren?
yes,
How many of them?
3 of them, my lord.
Grandchildren, all of them.
Yes,
So
In fact-
LSC's properties are in their name.
yes,
The grandmother wants it back.
yes.
Originally, it was in whose name?
Originally, it was in the name of
Grandfather.
yes, my husband, the husband of the yes. This is respondent number 1 hearing.
Your grandfather.
Yes, grandfather. And my lord, since there is a delay in filing the instant appeal, the connected IA has been filed.
Robert Saimoya is your father. Robert Saimoya is your father.
Yes, my lord.
Birmo is your grandmother.
Yes. Mother of Robert Saimoy Silo.
Initially, the property belonged to Salianpui Asylum.
My lord.
Correct.
My lord.
Then how it got transferred in your name? You mean the applicant's name?
My lord, there was an executed gift deed.
Gift deed.
Yes.
So on the basis of the gift deed,
Yes.
how many property? One or three?
Three properties.
Three properties.
In the each name of the appellants here.
As per the gift deed, so the three properties came to be transferred in the name of the applicants.
Yes.
Then later on, your grandmother.
And yes, that was challenged, saying that their signatures. My grandmother was saying that the signature of my grandfather has been forged.
Challenged by way of this declaratory suit.
Yes.
So during the pendency of the suit, Biagmoi died.
Died.
So your father,
Yes.
Robert Saimoya,
Yes.
he got himself impleaded
He had
as
filed,
the legal heir
Yes,
of
yes, my lord.
Biagmoi.
My lord.
Now, ordinarily, there's nothing wrong in that.
Fine.
But you say that Robert Saimoya and Biagmoi has a case.
My lord.
They have a dispute also.
Yes, my
What
lord.
is that case?
My lord, at page number 50.
In the appeal?
Yes, my lord. I apologize, my lord. This is at page number 54. Page number 54. Civil suit number 76 of 2016.
This is between?
This is between Robert Saimoya Silo and the instant appellants herein.
Then where is Biagmoi?
And my lord,
She's not a party.
from page, if your lordship could kindly come to page number 68. Amended plaint was submitted. Page number 68, amended plaint was submitted. And if your lordship could come to page number 69, serial number 8.
Newly pleaded.
Smith Biagmoi was implemented.
What is this civil suit regarding?
My lord, this is also
Same property.
yes, same property amongst others. There are also other properties, and however, the properties in declaratory suit were also challenged in this civil suit, my lord. So on the one hand,
So Robert Saimoya is your real
Yes.
father,
Real
biological father or
yes,
stepfather?
biological father.
Biological father.
Yes. On the one hand, here the instant respondent, my father had impleaded my grandmother as a defendant in
Yes, I've
in another
understood.
case, and
I've understood.
on the other hand, he had sought for substitution, and that was allowed, man.
So how the substitution was applied for?
Uh,
Didn't you file your objection?
We have filed, however, it was rejected, man. The application was allowed.
How many days delay?
My lord, there is a I apologize, my lord. I deeply apologize. There is no delay, my lord. IA is for staying the proceedings of the declaratory suit.
You forgot what you drafted also.
I deeply apologize.
Please write down. Heard Mr. Tilal Zekima, learned counsel for the appellant, who submits that by filing the you have invoked section 17.
My lord,
Is there no provision under the CPC? Apart from 151? What is the provision for filing appeal against the order?
My lord, order 43.
43.
My lord. Order 43 talks about appeal from orders.
Order 43, Rule 1, which sub-rule? Hmm? Would you like to re-examine this aspect? Or you want me to put a rider?
My lord, if I may be allowed to examine.
How much time? You should incorporate the provision. You just can't simply say 1 by 1.
My lord.
Inherent power.
Yes, my lord.
You cannot file an inherent power FAO by way of inherent power. Give me that Mizoram Civil Codes Act. Please write, Mr. Tilal Zekima, learned counsel for the appellant, submits that he may be given a week's time to examine the provision under which and first appeal against the order would be maintainable. List again after a week.
Obliged.
Hearing item 10.
Anyone? Ms. Linda, you're there? This against what? Acquittal? It's against conviction.
Yes, my lord. Against conviction.
Why have you filed this appeal?
My lord, we agree with the judgment order where the sentence was reduced, my lord, from 302 to 304.
Yes, tell me.
My
What are
lord,
the
this is
facts?
a case of murder.
Mahak, you may go.
I'll take a lordship first to the FIR. At page 2 of the paper book.
Yes.
This is the FIR filed by the brother of the deceased. This is dated 27/8/2016. To the officer in charge, Lungde Police Station. On the night of 27/8/2016 at around 10 p.m., my elder brother Silal Somliana, son of Silal Rinomba, who was roaming around the streets of Zone Huai, was stabbed to death with a knife by Stephen Lelchoi Liana of Long Klai. I therefore request you to take legal action as per the law of the land. This FIR was filed on the same day.
Filed by the brother,
But brother,
younger brother, elder
younger,
brother.
younger brother. And the next page is the charge consideration wherein the respondent has pleaded not guilty and claimed for trial. And I'll take a lordship to the evidence. We have 15 witnesses. However, most of them are Caesar witnesses and not important. So I'll take a lordship to the important one. The first witness is at page 18. This is the informant.
How many witnesses you said?
15 witnesses, madam.
15 witnesses.
15 witnesses. However, most of them are Caesar witness. We have one eyewitness and we have 2 IO.
Yes. 18.
Page 18, this is the informant. I know the accused person who is present in court today. On 27/8/2016, at about 9:45 p.m., while I was sleeping, I received a phone call from my uncle Thangura, informing me that my brother Silal Somliana had been allegedly stabbed by the accused and to immediately come to the Christian Hospital, Serkon. I was accompanied by my neighbor to the hospital. On my arrival at the hospital, my brother had already succumbed to his injuries and pronounced dead. I immediately went to the police station, Lunglei, to submit FIR. Exhibit P1 is the FIR submitted by me, and P1A is my signature. Here, well, he's just the informant, so even the cross-examination, there's nothing much to say in the cross-examination. So the incident happened on 27/8/2016, and he was immediately informed, and he has filed the FIR. And we have PW number 2 and 2 to 8, my lord, they are the Caesar witness. I don't think these are very important, 2 to 8. The knife, the murder weapon was seized, and the apparel of the victim, the deceased. Yes. I'll take your lordship to the most important witness, PW number 12, which is at page 30. This is the friend of the victim, of the deceased victim, who was present all along. It's not a very long one, so I'll read it out, my lord. I know the accused person who is present in court today. I do not remember the exact date of incident, but after I had returned from work and taken dinner, I invited Soma, who was deceased, to accompany me to the house of Debu, Mystery, to inquire whether he had any work where we could earn our livelihood. Inside the house of Debu, the accused was present in the inner room, and he called me to enter the inner room. The owner of house Debu was not present, and I did not want to enter the inner room in such a situation. The accused called me 3 times and asked for a liquor, and came out afterwards from the inner room and taunted me by calling me Nang Chakma Meme. I rebuked him not to insult me in such a way. I entered into an argument with the accused, however, was stopped by my companion Soma. Soma escorted me outside the house so as not to enter into any altercation. I, along with Soma, left the house of Debu and proceeded towards my house, which is located at Middle School Wing. On the way, we had to pass through the volleyball court. After we left the house of Debu, the accused followed us near the Aganwadi school. I entered into a fight with the accused. The accused first punched me 3 times on my face, and thereafter I retaliated. My companion Soma repeatedly tried to stop us from fighting, and I could not retaliate properly. Some members of junior TKP who had come out on the road after their service broke up the fight and informed us to return home. My companion Soma and myself proceeded towards home. The victim was following me at a short distance since he was busy with his mobile phone. When we reached near the road junction of Main Road opposite the house of H. Thang Ming Liana, the accused rushed from behind, and I saw the accused strike the victim on his stomach. The victim cried out that he had been stabbed by the accused. I tried to follow the accused and grabbed him. However, since the victim appeared to be in a serious state, I did not follow him and tried to look after the victim. I cried out for help that he had been seriously injured and stabbed. The son of H. Tlang Ming Tang came out, and when he saw the situation, he brought his gypsy with which we carried the victim to Christian Hospital, Serkon. Sometime after we reached the hospital, the victim was reported to have succumbed to his injuries. Later, I accompanied the dead body of victim to Civil Hospital, Lunglei, for post-mortem. So this is the PW number 12, who was having some arguments with the respondent. And the victim deceased was the one who was trying to stop the fight. However, the respondent had stabbed the deceased. Yes, I'll come to that, madam. The cross-examination. It is a fact that the accused did not have any misunderstanding with the victim. First point, there is no misunderstanding. It is a fact that I do not know whether the accused intended to murder the victim. Number 3, it is a fact that I did not see the weapon allegedly used by the accused. Number 4, it is a fact that I entered into a fight with the accused and had put him on the ground and punched him several times. Number 5, it is not a fact that the victim was also fighting with the accused. It is not a fact that I had entered into an argument with the accused in the house of Debu in connection with daily employment. It is a fact that one Mithun was present in the house of Debu. I do not know who else was present in the house of Debu. It is a fact that I had carried about 2 glasses of liquor into the house of Debu, and I and the victim took 1 glass each of liquor in the house of Debu. It is a fact that the victim did not take any liquor earlier on that night. It is not a fact that I am deposing falsely in the court today. Debu is the owner of the house. Yes, he was not present.
In that house.
Yes, they were inside the house, and on the way home, on their way home, this the PW number 12 and the deceased, they were walking towards their home when the respondent attacked them from behind.
So he's an eyewitness.
Yes, he's an eyewitness. And
What about the weapon used? Who has exhibited that?
the IO. PW number 14. And PW number 13 is a shop owner, my lord.
Truck owner.
Yes. Even though he was, did not see the incident, but he was the one who helped. Oh no. I'll read it, my lord. It's a short one.
Yes.
I do not know the accused person who is present in court today. I have only heard of him from other sources. I have a small shop located outside the road from the residence of H. Thang Ming Diana. I do not remember the exact date of incident. It was late night and some junior TKP members had come to my shop to make purchases. During this time, some other members shouted that someone had been stabbed and in fear had rushed into my shop and closed the door from inside. I went outside to investigate and saw one person rushing up the road after another person. At a distance of about 10 meters, I saw another person, victim. The person rushing after the alleged accused came back to look after the victim. I rushed inside my shop. After a short time, the person rushing after the alleged accused forced the door of the shop open and shouted for help. I also went out of the shop and saw the victim was already lying on the road. Other people had also gathered around. Later, the victim was allegedly taken to hospital. This person was also nearby. And in his statement, my lord, he has stated that someone was stabbed and he saw one person running after another person.
So who was running after whom?
The PW number 12 was running after the respondent after he stabbed the deceased victim. And here also he has stated that at a distance of about 10 meters, I saw another person victim. The person rushing after the alleged accused came back to look after the victim. So PW number 12, he saw PW number 12 running after the respondent, and later PW number 12 came back to look after the deceased victim.
Okay.
And PW number 14 is the IO. And 15 is also the IO. We have two IOs here.
Who's the first?
First is PW number 14.
Okay.
It's a little bit long one, my lord. I'll read it out anyway.
Yes, you have to read.
I know the accused person who is present in court today. On the date of incident, that is 27/8/2016, I was posted at Lunglei PS. On this night, we received information about untoward incident at Zone Y. Immediately afterwards, at about 10:30 p.m., an FIR was submitted by one Abraham Zoram Luna of Zone Y to the effect that one Cyril Somliana of Zone Y was allegedly stabbed by the accused. The case was registered and I was endorsed to conduct investigation. During this time, apprehending law and order problem, S.I.L. Lungwan had already proceeded to PO and apprehended the accused and escorted him to Lunglei PS. I arrested the accused immediately and sent him to judicial custody in order to avoid any untoward law and order problem on the same night. I examined and recorded the statement of the complainant. The victim was already brought to the Lunglei Civil Hospital. I proceeded to Lunglei Civil Hospital and found that the victim had already succumbed to his injury. I conducted inquest on the dead body of the victim deceased. I found 1.5 inches punctured stab wound below the navel of the victim deceased. The internal organ of the victim was protruding from the wound, and the doctor present and myself attempted to put in the internal organ. However, it was not possible. The stab wound was measured and it was found to be about 1.5 inches. I made seizure of the following clothes of the victim at Civil Hospital, Lunglei. Number 1, T-shirt, navy blue color, uh, stained with blood worn by the deceased. Number 2, half pant, navy blue stained with blood worn by the deceased. Number 3, blood sample of the deceased. After I conducted inquest, I, along with other police party, proceeded at the PO at Zone 9. The other police parties were already present at the PO and were in search of the alleged weapon used by the accused. The accused had earlier mentioned that he had thrown away the alleged weapon near the volleyball court at Zone 9. After detailed search, the alleged weapon, that is Khasi knife, measuring about handle 30 centimeters, blade 10 centimeters, was located near the pavilion of the volleyball court at Zone 9. I made seizure of the alleged weapon. I also made sketch map of the PO. On the next day, I made requisition for conducting PME. Thereafter, I proceeded to District Jail Lunglei, where the accused was kept under custody. I interrogated the accused. The wearing apparel of the accused was already in the custody of the warder Deng Rikuma, since the wearing apparel was camouflage in color and therefore not allowed to be worn inside the jail. I seized the following wearing apparel of the accused: camouflage long pant stained with blood, allegedly belonging to the accused, kept in the custody of Deng Rikuma, chief jail warder. I examined the companion of the victim who was present during the time of incident. I also examined other witnesses. I examined the nearby neighbors of the place of occurrence. I thereafter sent the following seized articles for forensic examination. Number 1, alleged weapon, Khasi knife. Number 2, camouflage pant of the accused. Number 3, T-shirt, navy blue of the victim, deceased. Number 4, half pant, navy blue of the victim, deceased. Blood sample of the deceased. I received the PME report and also the FSL report. As per the DNA examination report received from FSL, the following conclusions was reported. Blood stain on the alleged knife, alleged weapon, Khasi knife, was belonging to the victim, deceased. Blood stain on half pant of victim was belonging to the victim, deceased. Blood stain on camouflage pant belonging to the accused was of the victim, deceased. From the interrogation of the accused, I concluded that the accused, after quarreling with the victim, had gone back to collect the alleged weapon, which he admitted he found to be on his person and with which he committed the alleged offense. Accordingly, I presume that the accused had preparation to commit the offense. After I had conducted all investigation, I was transferred to Bung Mun PS, and therefore I handed over the case records to OC Lunglei PS. And this is the exhibit, seized knife and the blood sample, etc. And I'll read out the cross-examination. Page 35.
Yes.
It is a fact that from the statement of the witnesses, the accused was already present in the house of Debu. It is a fact that from the statement of witnesses, the argument had initiated between the accused and companion of the victim, Ma Moana, regarding taunting by the accused towards the companion as being Chakma. It is a fact that from the statement of witnesses, the accused had demanded the companion of victim to pour liquor in Hindi. It is a fact that there was no other report from statement of witnesses regarding any other argument between the accused and victim or his companion. It is a fact that I do not have any knowledge whether the accused had any intention to commit the offense. It is a fact that while conducting inquest on the body of victim, deceased, I found only one punctured wound on the body of victim measuring about 1.5 inches. It is a fact that I did not send the accused for medical examination on the date of incident since there was apprehension of law and order problem. It is a fact that the accused appeared to have sustained some simple injury on his face on the night of the incident. It is a fact that the alleged weapon could have been used for cutting vegetables. It is not a fact that the accused did not have intention to commit the offense. It is not a fact that I am deposing falsely in the court today. PW number 15, my lord, this I don't need to read it out, my lord. It's the new case IO. And
What was his role?
After he was
submitted the
handed
charge sheet.
over, yes, he submitted the charge sheet.
Yes.
Then I'll take your lordship to the 313 examination of the respondent. Page number 4. Question number 1. The evidence against you is that on 27/8/2016, after dinner, while you were inside the residence of Debu, a mystery, the victim and his companion H. Lal Monsanga came in. You asked H. Lal Monsanga a glass of liquor and taunted him by calling him Chakma Meme. He rebuked you and had argument. For fearing the situation being escalated, the victim escorted his companion out of the house. However, you chased them near Aganwadi school. You punched H. Lal Monsanga 3 times on his face, and he reciprocated you with punches. The victim, Silal Somliana, tried to stop the fight by grabbing the hands of H. Lal Monsanga, because of which he was unable to punch you as he intended. As members of Junior TKP crossed the place, they told the 3 of you to go away, and the victim and his companion were proceeding home. What do you have to say? Answer. The exact facts of the case as per the question put before me is not fully correct. I had come to Lunglei from Longklai, where I was accused of another criminal offense and had been earning my livelihood and also money for producing witnesses and materials in connection with the other case. I already had misunderstanding with the victim and his companion due to engagement as labor mystery. Since I was earning wages of mystery, whereas the friend of victim was earning wages of labor, although he was much senior. Due to this reason, the companion of the victim was jealous and would taunt me, saying that I was a rapist in the other alleged case. In fact, the companion of victim and victim had, before the alleged incident, intended to ambush me while returning from work on more than 4 occasions. I did not retaliate since I did not want to have another criminal case made against me. The instant incident also occurred due to the taunting from the companion of the victim and victim. The victim had in fact threatened me, stating that I would not return home alive on that night. They attacked me first and also were carrying a stick of firewood with which they intended to hit me. The incident occurred due to my self-defense. And question number 2. The evidence against you is that you still followed the victim and his companion from behind without their knowledge. When you overtook them near the round junction of the main road opposite to the house of Thangming Liana, you suddenly stabbed the victim Silal Somlian on his abdomen while he was using his mobile phone. You then went away upward. You threw the knife used by you to the volleyball court. What do you have to say? Answer is as above. And question number 3. The evidence,
As above means?
As above means answer to the question number 2, I think.
He
Question
admits.
number 1.
He admits it.
Not admit, my lord. I think he has stated before that there was some misunderstanding.
Okay, he's referring to
Yes,
that.
referring to the previous one.
Okay.
And question number 3. The evidence against you is that you stabbed the victim on his vital part vigorously, and it appears that you did the same with the intention of killing him. What do you have to say? Same as the answer, my lord. As answer is as above. And do you have any other thing to say? No. So in the 313 statement, he has made some allegations, my lord.
What is the name of the accused?
The accused, Stephen Lelchoy Liana.
Who is H. Lal Monsanga? Oh, he's the one.
He's
He's the friend of the victim.
companion. Yeah, the friend of the victim, who is the respondent number, the PW number
Okay.
12. And the victim is Silal Somliana. In
So
313,
the victim was holding the hands of the friend,
he was,
not the accused, to stop the fight.
yes.
Okay. As per the question number 1. Victim tried to stop the fighting by grabbing the hands of Nalman Sangha, because of which he was unable to punch you as he intended.
In 313, he has stated that the victim had threatened them. The victim and his friend had threatened him. And they were carrying a stick of firewood. But there is nowhere mentioned in the evidences. This is only an afterthought.
Any defense witness?
No defense witness.
What is that other criminal case which the appellant is having?
He has a POCSO case, madam.
The accused is having? POCSO
POCSO,
case.
rape case.
What has happened to that case?
My lord, the sentence were made to run concurrent with this rape and murder. He was convicted for 7 years in rape case. And in this case also another 7 years, but it was made to run concurrent.
By the same judgment?
Yeah.
Both cases were tried together?
No, my lord. Not together.
Okay.
That is why we have filed. That is one of our ground also, my lord.
No, which judgment came earlier? The POCSO
The
case?
POCSO case. While he was on bail, he had committed murder again. He had a rape case at Longklai. And while he was on bail, he had committed murder. Now, I'll take a lordship to the judgment of the learned trial court. It starts from page 37. And
Where is it written that the sentence is to run concurrently?
in the sentence hearing, my lord, pronouncement of sentence is at page 55 and relevant portion is at 56.
It says the sentence shall run concurrently with any other sentence that the accused is
Is
convicted of
earlier.
earlier. So court was aware about the other case.
Yes, it's mentioned here, my lord, in para 2, in the same page, page 56. It is submitted by the learned PP, Mr. ZDL Pianmoy, that the accused was already convicted in another case under the POCSO Act, and therefore the accused should be given her punishment, which should run consecutively. The prosecution has prayed for that. However, in the
There's no other details except for saying POCSO Act case.
no other details is mentioned.
Then how did you say that this convicted for 7 years in POCSO case? Any other indication anywhere?
No.
Then? So why do you say that this judgment should be interfered with?
Yes, my lord. The learned trial court, my lord, has made this. At page 51, my lord, the learned trial court has made some observation. Page 51.
Yes.
The last para, my lord. In appreciating the evidences adduced before the court, the sequence of events that led to the offense, it is seen that the accused had entered into an argument with the victim, deceased, and other persons. This, my lord, there's nowhere in the evidence regarding this. And in fact, I'll read again. In fact, it is seen that the accused was provoked due to an earlier misunderstanding regarding their daily employment, where the accused was charged for taking away the employment of the victim, deceased, and other friends. There is nowhere in the evidence regarding this also,
313?
only in the 313 statement. This fact is stated in the final report, and the final report, the charge sheet. Final report submitted by the police as follows. Ma Moana and Soma entered the house and Ma Moana advised him not to take up his already engaged job, as he was far more junior to him in carpentry works. And he further stated that there has already been an enmity between them with respect to their jobs. After he left Debu's house, he met with the same persons, Soma and Moana, on his way home at Zonghai, and they started making dispute with them, consequently fought with them with bare hands for the previous disagreement between them. The trouble was stopped by the people who lived around there. This fact is again reiterated by the accused in his examination under section 313. The accused has not denied the fact that he has caused bodily injury upon the victim deceased, but it was on provocation and did not intend to knowingly cause murder. The other evidences brought out before the court is circumstantial and medical reports which have proved the death of victim deceased. It is therefore a fact that there was death of the victim deceased, and this event was caused by the accused. It is argued by the learned PP that the accused had knowingly attacked that they had parted company after there was an altercation between the accused, the deceased, and his companion. It is submitted that the accused had intention to cause the death of the deceased, and therefore the offense does not fall under the exception provided under section 300 IPC. The learned defense counsel has, on the other hand, argued that the accused was provoked by the deceased and his companion, and therefore the offense was committed on the spur of the moment, and praised for the defense protection provided in the exception to section 300 IPC. On perusal of the evidences adduced before the court, it is seen that the victim and his companion had taunted and provoked the accused at their house where they were drinking country liquor, and had taken earlier occasion to misunderstanding due to their engagement as mystery labor in the locality where the accused was still a new resident. Although the accused had followed the victim and his companion after a short while it cannot be construed that the accused had pre-planned the offense and deliberately attacked the victim, knowing the consequences of such attack or offense. In the above circumstances, this court is of the considered opinion that the ingredients of section 300 IPC have not been proved beyond reasonable doubt. It is the considered opinion of the court that the accused is therefore guilty of offense under section 304 IPC, as he had knowledge that the act of stabbing the victim on the spur of the moment or a few minutes after the altercation was done with the intention of causing such bodily injury as is likely to cause death. In light of the above discussion and on appreciating the evidences adduced before it, this court is of the considered opinion that the accused, Stephen Lil Choi Liana, is guilty of offense under section 304 IPC. Hearing on quantum of sentence shall be heard on the next day. So, my lord, the court has based the whole story from the charge sheet and the 313 statement, and the court has not even considered the evidences of the witnesses, the prosecution witnesses. And even the court has stated in the judgment that the accused, the respondent, was the one who followed the victim and the companion from behind.
Who?
The respondent followed the victim and the companion from behind.
That is in the evidence?
Yes, my lord. Even in the judgment itself also, it's written here, out here.
Who is that?
Evidence of PW number 12. My lord. Page 30.
52 itself, the judgment.
Yes.
Although the accused had followed the
Followed the victim
victim
and his
and his companion after a short while, It cannot be construed that the accused had pre-planned the offense and deliberately attacked the victim, knowing the consequence of such attack offense. How did he attack?
From behind, my lord,
With what?
with the knife. So, even
So if you attack somebody with a knife, what would be the consequence? It's anybody's guess. So you were referring to the evidence
yes,
regarding the following from behind.
yes, my lord.
This is from the friend of the victim, PW12, I think.
PW 12, page 30.
He has denied in his cross-examination that it is not a fact that I had entered into an argument with the accused. For a moment, let us see the chart sheet where something has been taken from the chart sheet.
Yes, charge sheet is at page 94 onwards, my lord. What the learned trial court has taken is the statement given by the respondent himself before the IO. Should I read it out, my lord? Or the brief story of the case for prosecution in brief is that
No.
on
You can read from the third paragraph.
Thatpara, the accused person, Stephen Lelsoy Liana, son of H. Rim Lel Liana of Longklai, Chan Mari, Piazon Hoi Lungle, was immediately apprehended after informing the ground of his apprehension, and he was taken to safe custody and admitted his guilt. And he stated that on the night of 27/8/2016, after having supper and drinking in the house of Debu of Zonghai, in the same time, Mam Wana and Soma entered the house, and Mam Wana advised him not to take up his already engaged job as he was far more junior to him in carpentry works. And he further stated that there has already been an enmity between them with respect to their jobs. After he left Debu's house, he met with the same person, Soma and Mwana, on his way to home at Zonghai, and they started making dispute with them. Consequently, fought with them with a bare hand for the previous disagreement between them. The trouble was stopped by the people who live around there. After he was separated from them, he again chased up the same two persons with a knife, and he catch up and stabbed Silal Somliana, son of Silal Lalrinam of Zonghai, after he stabbed the victim. He consequently left the PO, and he threw the knife towards Zonghai volleyball court. He was formally arrested and recorded his statement, and also his arrest intimation was given to his relative. The accused person was immediately forwarded and remanded into judicial custody on 27/8/2016 in order to prevent the likely outbreak of law and order problems. Accordingly, the investigating officer and party conducted search to recover the aforesaid knife. The recovery of the said knife was made from Zonghai volleyball court as per the statement given made by the accused person.
Just a minute. This Mamwana is the friend of the victim,
Yes,
the person who says it was supposed to be Chakma. Is it?
yes.
Okay, we'll just take a short break and come back.
Okay. My lord, we have gone through the charge sheet also.
Come to page 99. These are the statements given by the witnesses before the IO.
Yes, these are the statement of the witnesses before the IO. Should I read it out, my lord?
Yes, you can. I've just noticed there's some translation here at page 100. The fifth line in page 100.
Yes.
Just read that. Stephen,
Stephen asked me to give him the fake alcohol that I brought with me, and I responded saying that I have none.
okay, come back to the previous page. See the vernacular, how is it written?
Stephen chuan no
Bedroom alo vea.
bedroom a hian bedroom alom via zu tlem ka ken lu chu Stephen a hian bedroom a min lo pero min tia.
So where's that fake alcohol? So this is the kind of translation we're having.
Yes. Fake, I think should not be fake.
The vernacular says claim, and they have translated as lem, zulem.
Muslim.
Anyway, please read the translation. Let's see how, according to the statement.
According to the statement of Ichlal Monsanga, son of H1 Ruma of Zongnoi Lungle, he stated that on the night of 27/8/2016, I visited Debu at his residence with my friend Silal Somliana. Stephen was already there in the bedroom of the house. Stephen asked me to give him the fake alcohol that I brought with me, and I responded saying that I have none. He made a racist Chakma remark at me, and I was a bit angered. As Cyril Somliana and I were afraid that there may be a problem, we decided to leave. Stephen came running after us, and he punched me 3 times near Aganwadi Center, while I punched him once on his nose. Soma and the people who were present around the area separated the two of us, and we headed home. When we reached the main road, Stephen once again caught up with us, and I thought for a moment that he punched Soma at his abdomen. Soma, however, held his stomach, saying that he was stabbed. With blood oozing out from his stomach and also with his intestine in view, we immediately rushed him to the hospital. Soma soon after succumbed to his injury at the hospital.
Now, who is this person who gave the statement?
Which one?
Ichlal Monsanga.
Ichlal Monsang, he's the friend. PW number 12.
Friend of the victim.
Yes. Ichlal Monsanga.
And the accused person is named Stephen.
Accused is Stephen.
Okay. Then what about number 2?
Number 2 is Ichlal Sanhima.
Who is he?
Ichlal Sanhima, let me see.
Who is the gypsy owner? The vehicle.
Ichlal Sanhima is, he appears as PW number 11.
11.
Yes.
He brought his gypsy and took the victim
Yes,
to the
he's the one who
hospital.
carried the deceased to the hospital.
Then serial number 3.
3 is Tokala. I don't, I don't think he appears at witness number 13. Page 32.
He's the shop owner,
He's the shop owner,
70 years of age.
70 years.
Nothing much.
Nothing much besides this.
Okay.
Lordship, we agree with the alteration of charge from 302 to 304. Even though we have witnesses who have, some of them are even eyewitnesses to the incident. And even the trial court admits that the respondent was the one who was running after the two, the victim and the friend. My lord, the trial court has based its findings only on the 313 statement given by the respondent as well as the charge sheet, which is not a substantive piece of evidence. And the trial court has not considered the evidence given before the court.
You have any authority?
My lord, today I was in a rush. I could not produce the authority. If I may be allowed to give the citation tomorrow, my lord.
Sure.
And
Anything else?
considering the character of the respondent also, my lord, he has been convicted in a rape case, and while on bail, he has committed murder. So he deserves maximum punishment in the case.
Yes.
That's it, my lord.
Yes, Mr. Indiana.
May I please, Your Lordship? My lord, here, from perusal of the evidence available on record, my lord, first what can be seen is there was a pre-altercation and there was a fighting and a punch, which was also stated by the PW number 12. And conviction was made by the lower court, the lower trial court, by relying on the evidence of those witnesses, by stating that there was a provocation on the part of the PW and also the victim, my lord. And if we read the cross-examination portion of those witnesses, my lord, if I may read those relevant portions of the evidences, it can be seen that there was a pre-altercation and provocation. If I may read the evidence of the PW number 12 also, at the which was already read by my learned friend at the cross-examination portion.
Yes.
If I may read the serial number 2 and 3 and 4, my lord, at page 31.
Yes.
It is a fact that I do not know whether the accused intended to murder the victim. Number 3, it is a fact that I did not see the weapon allegedly used by the accused. And number 4, it is a fact that I entered into a fight with the accused and had put him on the ground and punched him several times. So, from this recorded evidence, my lord, it can be seen there was fighting and provocation before the said incident. And also that the PW number 14, who is the case IO, stated in his examination that the alleged weapon, that is Kasi knife, was belonging to the victim, which can be seen at page 34 of the examination, page 34 of the paper book, my lord. If it can at the third para, my lord. Serial number 1.
Yes.
Serial number 1 is blood stain on the alleged weapon Kasi knife was belonging to victim deceased. Here, the case I was stated that the knife was belonging to the victim deceased.
So from where did he get the knife? If it belongs to the deceased.
Blood stain.
It may be here blood stain. It means blood. It may be. It may
The
mean
blood
to
stain was
say-
belonging to the deceased, not the knife. Are you trying to say the knife belongs to the deceased?
Yes. Yeah. It was stated like that. Yes.
Let us see the FSL report. Is it available anywhere?
Yes. FSL report is available. '92 of the paper book.
Yes, 92.
If I may read, my lord.
Yes.
Blood were detected from the stains of exhibit B, C, D, and E and were subjected for DNA isolation by organic extraction method. Exhibit A and F were subjected for DNA isolation by FTA card extraction method. DNA extracted from the above mentioned exhibit A, B, C, D, E, and F were subjected to multiplex PCR reaction for co-amplification of the 15 STR loci
You
and
straight away come to conclusion number 1.
malor.
Blood stains from
On the
exhibit B.
basis of the above observations, it was concluded that the blood stains from exhibit B, knife Kasi Chemte, 13 centimeters handle, 10 centimeters blade with suspected blood stain was that of the victim.
So this is the blood stain, not the knife.
malor.
You're trying to make a submission that it was a knife
It was
of
Yeah,
the deceased
that I-
himself. That is not the
that was a blood. Seems to it has to be a blood stain. Yes, my lord.
blood stain only.
My lord. And blood stains from exhibit D, half pant, navy blue color of the victim with suspected blood stains was that of the victim. Cyril Somliana. And the blood stains from exhibit E, camouflage long pant of the accused with suspected blood stain was that of the victim, Cyril Somliana. That is exhibit A. This is with regard to the examination of blood stains, my lord. Blood stains collected from the knife and also from the clothings of the victim. And here, my lord,
What about medical examination?
the medical examination is
Or PME
the
report?
examination of the medical doctor.
PME report?
The PMES at page 78.
78.
Yes, my lord. 78 and 79. Till page 80. My lord, if we may see the detailed description of injury at page 80.
Yes.
It is written like this, my lord. The entry wound is penetrating lacerated wound, 2 inch
Approximately.
horizontally oriented, located at umbilical region of abdomen. No other external injury found. There is no exit wound. I cannot clearly see.
No cut. There is no cut wound.
There is no cut wound, exit wound, it seems, my lord. Exit,
There is no exit wound.
exit
Okay.
wound. The track or brack or something like that is approximately 4.5 inches deep, evenly cut, directed from front to back,
Back.
slightly left to right, and upward. The track lacerate and perforate the abdominal wall and traverse. That I cannot exactly read.
Is it typed out anywhere?
There is no,
It is not typed out, isn't it?
my lord, yes, it seems. My lord, in order to clarify the exact situation of wound, it may be relevant to read the examination of the medical doctor, my lord, which is at page 28. Page 28, my lord.
Yes.
I do not know the accused person who is present in court today on 28 2016 at about 8 a.m. I was on duty roster at Civil Hospital Longley to conduct postmortem examination. Accordingly, I conduct PME on the dead body of the victim, deceased Sila Somlian, 33 years. On examination of the body of deceased, it was observed that the wound was stitched on the previous night. After removing the stitches, I found approximately 2 inches penetrating lacerated wound on the horizontally oriented umbilical region of abdomen. No other external injuries were found. There was no exit wound. The depth of the wound was approximately 4.5 inches, depth evenly cut, directed from front to back, slightly left to right and upward. The track lacerates and perforates the abdominal wall and transverse mesocolon. On examination of the wound, it appeared to have been vigorously inflicted since the wound was larger than the alleged implement. The cause of death was determined to be due to hemorrhagic shock due to the injury on abdomen. There was approximately 2 liters of intraperitoneal blood present inside the abdomen. Upon cross-examination, here it states like this. It is the fact that I observed and found only one stab wound in the body of the deceased. Meaning that, my lord, this is not the multiple stab, seems. It's like a single step only, my lord. Which is also corroborated by the evidence of the PW number 4, the case IO, my lord. The case IO in the cross-examination portion at the serial number 6, that is page 35 of the paper book, my lord. Page 35. Serial number 6. It is a fact that while conducting inquest on the body of victim deceased, I found only one punctured wound on the body of victim measuring about 1.5 inches. And my lord, with regard to this single step wound, and by considering the earlier pre-altercation and fighting between the accused and the friend of the victim, it seems that there was a provocation which resulted in the heat of passion, and from considering the statement of the PW number 12, who is the the friend of the victim, they were, after they left the house of Mr. Debu, after they left Mr. Debu's house, they entered into a fight near the Anganwadi school. That is as per the evidence given by the PW number 12. So it seems that there was a heat of passion in the course of their in the course of this incident. And that, my lord, the intention was not known when cross-examined. The case I also stated at the cross-examination portion by saying that I do not have any knowledge whether the accused had any intention to commit the offense. That is his statement that is the statement of the case IO. So the PW number 14, who is conducting the inquest, also stated that there was a heated argument and there was no knowledge of intention beforehand, and there is only one punctured wound. And the PW number 15, Esail Nuntluanga, in his who is submitting the charge sheet, stated that there was no previous preparation of the accused before the incident, which can be seen at page 36, my lord. There was no previous preparation on the part of the accused, before the incident. My lord, page 36, cross-examination portion, serial number 5.
In the chief, he says that all necessary investigation was already carried out and conducted by my predecessor. He has not conducted any investigation on his own.
Yes, my lord.
So from the documents is available, there was no previous preparation on the part of the accused before the incident. What does it mean?
He admitted that there was no previous preparation, but He's not the one who is conducting the investigation.
He basically submitted the charge sheet, that's all.
Yes, my lord.
Investigation was done by the first IO.
My lord.
You were talking about the provocation and all that. Where is the provocation? Fight was there, no doubt. But where's the provocation?
My lord.
Who went running after the victim and his friend? It was the accused. After they left that place, that house,
From the evidence of the PW in Murthrop, what can be seen is that they are fighting near Anganwadi school after they left the house of Mr. Debu.
correct. So how did the fight happen? Two persons have to be there to fight. How did the the accused person get to that Anganwadi center? Because the evidence says that the friend and the victim had left that house, Debu's house. Debu, isn't it? His name is Debu or something.
Debu, yes, my lord.
They met in Debu's house. They had some sort of exchange. But the friend of the victim just prevented him and he took him away, anticipating that further argument will be there. So he took him away. And while they were going near the Anganwadi center, the accused person caught up with them again. It seems he was following them. That is there in evidence. 14, PW 12.
Yes, my lord. After it was written like they entered into a fight. After they left the house of Mr. Debu, they entered into a fight near Anganwadi center, under Anganwadi school. He stated that the accused first punched me 3 times on my face and thereafter I retaliated, he stated.
After we left the house of Debu, the accused followed us near Anganwadi school, and I entered into a fight with the accused.
Here,
Then the fight was broken up. Some TKP, junior TKP
Yes.
members had come, so they broke up the fight along with the help of the deceased victim. Then they proceed towards their home. Victim was following them again.
later, it was like the victim was following his friend at a short distance, and later the incident happens.
It says victim was following me at a short distance since he was busy with his mobile phone. Who was busy with the mobile phone?
Seems the victim, Malan. Seems like the victim.
Okay, the victim was following me at a short distance. When we reached the house of so-and-so, the accused rushed from behind and I saw the accused strike the victim in the stomach. According to the trial court, it comes under that exception clause. It's not at 302 but 304.
Yes, my lord.
What is the exception which according to you is applicable here?
My lord,
How many exceptions are there? Let us see section, you have this IPC with you?
Yes, my lord, I have
Section 300.
300. If I married 300, my lord, section
Yes.
300. Except in the cases hereinafter accepted, culpable homicide is murder if the act by which death is caused is done with the intention of causing death. Or, secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. Or, thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Or, fourthly, if the person committing the act knows that it is so eminently dangerous that it must, in all probability, cause death or such bodily injury as is likely to cause death, and commit such act without any excuse for incurring the risk of causing death or such injury as aforesaid.
So which is the exception attracted here? Trial court has not said anything, isn't it?
Perusal of
There are 5 exceptions, I think.
my lord. Perusal of the judgment and order stated that there seems to be a sudden provocation. If
So what is that sudden provocation? The law says if it's sudden provocation and the person acts at the spur of the moment, perhaps it cannot be under 302.
my lord, yes, my lord.
Now, on the given facts of this case, from the evidence, can you point out anywhere that it was a sudden provocation? So the appellant, the accused person had no other option but to sort of, like react with a knife.
My lord, here if I married the
These duos, the friend and the victim,
my lord,
victim and his friend, they were not carrying anything, were they? They were carrying any arms?
no,
not carrying.
no, not carrying anything. It seems, but he's busy with his. It seems with his mobile phone.
Mobile phone. So mobile phone is not a weapon.
My lord.
So why did he have to take out his knife and poke him with a knife? And say that this is a sudden provocation. While every time you are following to the victim. If they had followed him instead, the other way around, then it's a different thing. They were walking away and he was following them everywhere.
What can be seen is that, my lord, they are fighting near that Anganwadi school.
Yes. How? Because the
Yeah.
accused came running there to catch up with them. And he gave 3 blows. And this friend, he retaliated, giving back the blows. His friend, the deceased, tried to stop him. And the TKP, junior TKP boys were there. They also came and interfered. Then they were separated. Later on, while the victim was looking at his phone, you were walking together at some distance. I mean, they were walking together with his friend. Then the accused person came running and he jabbed him with something. And that something happens to be that khasi knife. And the person who was having a fight with the accused said that the victim shouted that he has been stabbed. That is the story. So exception 1, when culpable homicide is not murder. This is grave and sudden provocation. Then exception number 2 is exercise in good faith, the right of private defense. Number 3 is public servant for public justice in good faith, in a lawful and necessary so discharge of duty. Number 4, culpability not without premeditation, in a sudden fight, at the heat of passion. Perhaps exception 1 and 4. Exception 1 and 4 may have some clarity. Suppose it's sudden fight without premeditation. 1 says sudden provocation.
My lord.
Your case that there was provocation. But in order to attract this exception 1 or exception 4, the evidence on record will have to support your case.
My lord, here what can be seen is that the incident is not a cold-blooded act. It's the what you can see is there was a pre-altercation. There might be some feeling of anger on the part of the accused also when they had the pre-altercation, and there might be a heat of passion, and from that onwards, the subsequent incident happens at near the Anganwadi school, and later the present incident happens when the accused person followed.
Anganwadi school was okay. They were using fists. Okay, man to man, they were having a fight.
Yes.
But later on, the second fight, that was the fatal one. He came with a knife. And the knife also had penetrated near the navel area. And the blood which was still remaining inside the body also, you just read out.
My lord.
About 2 liters still remain in the inside the thing. And the description of the infliction of the wound is vigorously inflicted. That is what the doctor said.
Yes, my lord.
On examination of the wound, appeared to have been vigorously inflicted, since the wound was larger than the alleged implement.
In that regard, my lord, what can be seen is it's a one-step wound and not a multiple step. But it was stated like vigorously inflicted.
Means with full force.
The actual depth is not mentioned, my lord. But it stated like 4.5 inches as per the evidence of the medical doctor.
Yes, the PMA report also said that. All right. Anything else?
My lord, in that regard, what I'd like to submit is that there was a pre-altercation which resulted in the present incident. There was a provocation, there was a fighting, and a punch was given to the accused several times, and there was a heated argument, and there was no intention to commit the act which can be punished under Section 302. Instead of that, the lower trial court had convicted under 304. And in support of my submission, my lord, here, I'd like to rely upon the authority of the Honorable Supreme Court. First, my lord, Satish Narayan Sawant versus State of Goa, reported in 2009, SCC volume 17, page 724. 724. Paragraph 40 and 41.
This is regarding?
This is regarding the factual, the
Provocation?
provocation, yes, my lord. Which provocation, which resulted in the case falling under section 300, part 2 IPC.
Hmm.
If I may read, my lord.
Yes.
Para 40 and 41. That being the well-settled legal position when we test the factual background of the present case and the principles laid down by this court in the aforesaid decisions, we are unable to agree with the views taken by the High Court. As already noted, it is quite clear from the record that there was an altercation preceding the incident. The place of occurrence is a residence inhabited by both the parties, and there is no evidence on record that the deceased was armed with any weapon. Initially, the appellant accused also did not have any weapon with him, but during the course of the incident, he went inside and got the knife, with the help of which he stabbed the deceased. PW7 in his cross-examination has categorically stated that death due to stab injury was in consequence of injury 1, and all other injuries were superficial in nature. So, it was only injury 1 which was fatal in nature. Factually, therefore, there was only one main injury caused due to stabbing, and that also was given on the back side of the deceased, and therefore, it cannot be said that there was an intention to kill or to inflict an injury of a particular degree of seriousness. Records clearly establish that there was indeed a scuffle between the parties with regard to the availability of electricity in a particular room, and during the course of scuffle, the appellant also received an injury, which was simple in nature, and that there was heated exchange of words and scuffle between the parties before the actual incident of stabbing took place. There is therefore provocation, and the incident happened on the spur of the moment. That being the factual position, we are of the considered view that the present case cannot be said to be a case under section 302 IPC, but it is a case falling under section 304 part 2 IPC. It is tried law that section 304 part 2 comes into play when the death is caused by doing an act with knowledge that it is likely to cause death, but there is no intention on the part of the accused either to cause death or to cause such bodily injury as is likely to cause death.
Yes.
And my lord, secondly, I'd like to rely upon the case of Ruliram and another versus State of Haryana, reported in 2002 SCC volume 7, page 691. Paragraph 13, 14 and 15, my lord. In versus Singh versus State of Punjab, Vivian Bose, speaking for the court, explained the meaning and scope of clause 3. It was observed that the prosecution must prove the following facts before it can bring a case under section 300. Thirdly, first, it must establish quite objectively that a bodily injury is present. Secondly, the nature of the injury must be proved. These are purely objective investigations. Thirdly, it must be proved that there was an intention to inflict that particular injury, that is to say, that it was not accidental or unintentional or that some other kind of injury was intended. Once these three elements are proved to be present, the inquiry proceeds further, and fourthly, it must be proved that the injury of the type just described, made up of the three elements set out above, was sufficient to cause that in the ordinary course of nature. This part of the inquiry is purely objective and inferential and has nothing to do with the intention of the offender. The ingredients of clause thirdly of section 300 IPC were brought out by the illustrious judge in his tense language as follows. To put it shortly, the prosecution must prove the following facts before it can bring a case under section 300 thirdly. First, it must establish quite objectively that a bodily injury is present. Secondly, the nature of the injury must be proved. These are purely objective investigations. Thirdly, it must be proved that there was an intention to inflict that particular bodily injury, that is to say, that it was not accidental or unintentional, or that some other kind of injury was intended. Once these three elements are proved to be present, the inquiry proceeds further, and fourthly, it must be proved that the injury of the type just described, made up of the three elements set out in the above, is sufficient to cause the death in the ordinary course of nature. This part of the inquiry is purely objective and inferential and has nothing to do with the intention of the offender. The learned judge explained the third ingredient in the following words. The question is not whether the prisoner intended to inflict a serious injury in a trivial one, but whether he intended to inflict the injury that is proved to be present. If he can show that he did not, or if the totality of the circumstances justify such an inference, then, of course, the intent that the section requires is not proved. But if there is nothing beyond the injury and the fact that the appellant inflicted it, the only possible inference is that the intended to inflict it, whether he knew of its seriousness or intended serious consequences, is neither here nor there. The question, so far as the intention is concerned, is not whether he intended to kill or to inflict an injury of a particular degree of seriousness, but whether he intended to inflict the injury in question. And once the existence of the injury is proved, the intention to cause it will be presumed unless the evidence or the circumstances warrant an opposite conclusion. Nothing else, my lord. These are the two authorities that I'd like to submit before the Honorable Court, my lord. And my lord.
Your Lordship, if Your Lordship will be passing orders, I have one more submission to make, my lord. I'd like to point out that the learned trial court has convicted the appellant under section 304. Nothing is mentioned whether it's which part, under which part, my lord. There are two parts under section 304. Yes. 304. Punishment for culpable homicide not amounting to murder. Whoever commits murder, culpable homicide not amounting to murder shall be punished with imprisonment for life or imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine if the act by which the death is caused is done with the intention of causing death or of causing such bodily injury as is likely to cause death. Or, there's another one, or with imprisonment of either description for a term which may extend to 10 years or with fine or with both, if the act is done with the knowledge that it is likely to cause that, but without any intention to cause that, or to cause such bodily injury as is likely to cause that. This is another point which I have mentioned in my memo of appeal, my lord. The court is silent on which part he has been convicted. And I have given one citation. I think this will suffice, my lord. 2010. One is in prison for life. Yes. No.
My lord, in that regard, yes, it said like it may extend to 10 years in both the case.
In,
I'm reading the provision of 304, my lord.
Yeah. 10 years. I think it's 7 years. Okay, couldn't like what? Yeah. To talk to about 10 years.
It writes like it may extend to 10 years and shall also be liable to fine if the act by which death is caused is done with the intention of causing the death or of causing such bodily injury as is likely to cause death. And part 2 is, my lord, or with imprisonment of either description for a term which may extend to 10 years.
10 years.
Here, it may extend to 10 years, but the minimum is not mentioned.
Yes.
My lord.
And the citation is, my lord, 2010 12 SCC 310. Para 14 is in relation to 313 explanation, and para 29 is regarding motive. Para 14 and 29. Para 14, it says that the court may rely on a portion of the statement. However, such statement should not be made considered in isolation, but it should be in conjunction with the evidence. And para 29. Para 29. Says here, with the development of law, now it is a settled principle that motive is not absolutely essential to be established for securing conviction of an accused who has committed the offense, provided the prosecution has been able to prove its case beyond any reasonable doubt. In the present case, the motive suggested by the prosecution appears to be reasonable and is in consonance with the behavior of a person placed in a situation like the appellant. And it is also difficult to believe that a person would commit suicide without any provocation or incident immediately preceding the occurrence. The explanation rendered by the appellant has correctly been disbelieved by both the courts, and we see no reason to take a different view.
Okay.
Mr. Joseph was waiting for it. I think they are going to mention it, madam.